Afternoon, Council. Afternoon, ladies and gentlemen. This is a matter of the state of Wisconsin versus Brendan R. Dassey. It's 06-CF-88. You were last in court on May the 12th, 2006. Court ruled on a motion brought by the defense to suppress a number of statements. After the court ruling, we started to discuss another motion that the defense had brought relating to surety for bail. The district attorney at that time, or the special prosecutor, I should say, requested time to file his own motion, and I'll get into that in just a minute. I've had a chance to talk to the counsel in chambers prior to coming on the bench, and before we start with this hearing, I'm going to address myself to the defendant. Mr. Dassey, would you pull that microphone close, please? Mr. Dassey, counsel, and I'm referring herein in this case both to defense counsel and to the special prosecutor, talked, as I mentioned a moment ago, in chambers before we came here, and I'm going to ask you a question, and I want you to answer it for me, okay?
Mm-hmm.
You have to answer out loud.
Yeah.
Are you requesting that your current counsel be replaced by someone else?
Yes.
And you've made that request of him, have you?
Yeah.
You understand that in the event he is replaced by someone else, you can't simply go on requesting that new counsel be appointed for you.
Yeah.
That essentially you may, and I'm not saying you will, you may get only one shot at this.
Yeah.
You understand that, Mr. Kaczynski? Have you, and I'm not asking you to reveal anything here that would violate any lawyer-client relationship, but you are, I take it, aware that there is Mr. Dassey has raised some question. Is that right?
Meow. Yes, Your Honor, at the end of a discussion we had earlier this week.
Do you believe that based on, and again, I'm not asking you to reveal anything that would violate the rule of confidentiality, but do you believe that this request is his free and unfettered choice?
I'm not sure about that, Your Honor. I have received information that there has been an ongoing campaign by Mr. Dassey's co-defendant to encourage him to obtain new counsel that might be more to his co-defendant's liking.
So you are, without saying so, directly suggesting that others may be trying to control the determination of who represents whom here.
I, 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 I believe there's at least a reasonable possibility of that, Your Honor, because my interactions with Mr. Dassey have been quite pleasant. We haven't had any substantial arguments or anything of that nature.
All right, I'm going to turn to the special prosecutor. Do you wish to be heard, Mr. KRATZ?
Well, Judge, eventually I do. If, in fact, there's going to be a request of the court for substitution of counsel, and if Mr. Kaczynski is indicating to the court, which I believe he is, that there's a possibility of some unexpected influence on Mr. Dassey or on this decision for the appointment of counsel that comes from somebody other than Mr. Dassey, that is certainly something that the state has an interest in being heard on. If the court agrees that this is something that is appropriate for an evidentiary hearing, I'm going to ask the court to direct Mr. Kaczynski to submit on Mr. Dassey's behalf a written request for substitution of counsel, giving the state an opportunity not only to investigate, but to be heard, and that in a very short time frame, the court does schedule an evidentiary hearing to decide on that request.
All right. The court is reluctant at this point to proceed even on the motion when we have had the expression of the defendant that he wishes replacement counsel. Whether this is really his expression or whether it is something that is coming from elsewhere, I don't know. But before Mr. Kaczynski, I think you can or should be replaced. I think we ought to have some sort of evidentiary hearing. I would request that you submit then in writing a request for substitution, and again, this is a request for substitution. This isn't necessarily guaranteed to be granted, but the court in the past has given great leeway to that. On the other hand, there may be some other issues that should be explored before there is any successor counsel appointed, if needed. There is. With that said, I'm unwilling to proceed today on this motion. I'm the as I pointed out to you. I think once the defendant says that he wishes someone else for ill or good reason, I don't believe that this court ought to be proceeding. Anything else, gentlemen?
No, Judge. Just the scheduling of that hearing.
How about Friday, June 2nd, the afternoon?
I've got a couple of I've got a felony sentencing in Oshkosh. I could ask the judge to move it if the court wants me to.
Would you do that, please?
Okay.
How about you, Miss KRATZ?
I think that would be available. Certainly Wednesday or Thursday. I know it would be easier, but I can make it work, Judge, on the 2nd.
Yeah, I have trials scheduled all day on Wednesday and Thursday. Otherwise, I'd certainly try to accommodate the both of you, but I would propose 1:30 Friday afternoon, June 2nd.
That'll be fine, Judge.
In the event the defendant is no longer what he insinuated here today, we simply proceed with the motion bail at that time. All right, anything else?
I don't believe so, Judge. Thank you.
No, Your Honor.
All right, we're adjourned.